Hello, it's Philip Taylor speaking from Richmond, Green Chambers in London. Today I'm looking at a book from Marc Beaumont. I've reviewed Marc's books in the past, but this is a particularly important book. I was very pleased to read it. It's called Beaumont on Barristers, but it's got a subtitle, A Guide to Defending Disciplinary Proceedings. And I think all barristers should have a copy of this book because of the problems associated now with the grievance system we have of really substantial and massive claims which are sometimes made about complaints without any form of real justification. I think Marc has really put the issue right to the front with this work. Let's have a look at it. It comes to us from Law Brief Publishing. It's basically a practical guide. There's the book itself. There's the spine. Now on the back you probably can't make much out of it with the inverted copy, but there isn't an index at the back, but there is a detail of all the previous publications of Law Brief Publishing, and then there's a useful series of chapters. I think there are 12 in total. That's the front page. You can see the basis of the book there. Then there's some information about the book. Then there's a very nice dedication. I only review, and Elizabeth and I only review books which we think have got merit. This one certainly does, and it's very important to mention the dedication because there's a lot of work that goes into these books. Lord Hendy has produced a very interesting foreword to the book, explaining basically in some general terms what the book's about, and then the preface by Marc sets out in a lot more detail the information concerning the way that the book has come about and the reasons for it. Then you'd have a table of cases. There is something right at the front of the book which is basically a bibliography about Marc Beaumont. He's basically one of the founders of the direct access scheme, and of course he's done a huge amount of work in disciplinary proceedings, and this list of cases includes reported and non-reported cases. You can see the list of them all the way through, and he's been involved in a large number of them over the years, with the very checkered history that the disciplinary proceedings process has. There's a table of statutes there. Then there are 12 chapters in total looking at various areas of what needs to be done, how everything is dealt with, the effect of disciplinary proceedings, starting at chapter 1. You can see that there is some footnoting at the bottom. There is paragraph numbering at the sides. There is no index, but you should be able to find what you're looking for depending on what problem you are actually facing by looking at this book. It's a cheap book as well. It's not an expensive book. It's well worth the money because I think everybody needs to have a copy of this because of the situation we're facing in the 2020s, which is, as I say, a lot of scurrilous allegations being made. And it's very difficult sometimes to separate the serious allegations from the trivial and the malicious. What do I say about this book? Well, I was the lead writer on this particular review, and I've got a quote. Hitting the pressure points comes from Marc's statement, and it's basically looking at where the whole issue of the process of defending when there's a disciplinary proceeding, how it actually works. The subtitle I've given for the review is An Excellent Well-Written Guide for Those Defending Barristers. As I say, it comes to us from Law Brief Publishing, who produce these excellent practical guides, and this is really one in the series. Anyway, as I say, Marc Beaumont certainly hits the pressure points here with his excellent new book, which is called Beaumont on Barristers, A Guide to Defending Disciplinary Proceedings, and that's exactly what you're getting. The title is the first ever publication which examines in some detail the professional disciplinary proceedings against barristers from the perspective of the defence. Obviously, barristers are the ones who prosecute, and the whole of this area is quite unsavoury and an area which is of great embarrassment to anybody who actually is facing this sort of proceeding, whether you're innocent or guilty, and the way, in fact, the whole process operates. Because we consider, having read this book, that the work is written by an expert. The quote is, it's a significant, learned, but also user-friendly addition to the library of those involved in such proceedings as disciplinary proceedings. And of course it will be of use whether you're an advisor, an advocate, an adjudicator or a protagonist. Clearly those barristers who prosecute or pursue the allegations should also read it to know where they're coming from. Obviously they have a difficult task as well, and it must be a pretty unsavoury job to have to do, because with the changes that took place in the year 2006, the investigation on what is called the prosecution of barristers has now been undertaken by a body independent of the Bar Council, which we know as the Bar Standards Board. Again, there's a lot of confusion about what powers the Bar Council have and what powers the BSB have. And of course, with the passing of the Legal Services Act in 2007, under the Labour government at that time, the Bar Council, and so the BSB as it was came to be known as, gained statutory legitimacy as the regulator of barristers. Hitherto there had been a different approach, and the floodgates were well and truly opened. And we use the word, of course, prosecution here because the process is effectively a criminal prosecution in the manner from the outset. And I think that's something many people will not understand until they read the book and they understand exactly what powers are used. Because in many ways the defendant doesn't have the same rights at all as he or she might have in a criminal trial. I say that guardedly because it's a matter of opinion, but I'm putting that forward because the book itself tries to identify how the process operates. And of course, since 2006 there's been, quote, an unprecedented growth in litigation involving the Bar Standards Board. Beaumont, of course, usefully sets out the history with the replacement of the historic process of visitors to the Inns of Court and approaching them. Again, a very much more gentlemanly approach, whereas now it's very much a raw prosecution approach without the CPS being involved. Obviously there's a right of appeal to the High Court through an act, the Crime and Courts Act of 2013, and of course the result has been the production of a series of important High Court decisions set as precedent. And of course what Marc Beaumont does here is he's produced, as I say, this user-friendly practical guide which starts with a description of the sometimes traumatic and disruptive effect on disciplinary proceedings, because it's basically the end for some of their careers, and also of course they've spent a huge amount of money qualifying. That's something that should be borne in mind, of course, bearing in mind the difficult situation we've faced in the middle of 2020 with effectively the beginnings of a depression. Beaumont of course goes on to explain in some detail the effective collapse of the bar's system of discipline, and that's really what's happened, which has led to where we are today. The general decay in the process led to the creation of the Bar Tribunals and Adjudication Service from 2014, which is what we currently have. That again will not be something many of us know much about, but you do need to know about this should you have a client who decides to take matters further, many of which of course are malicious. And there's a huge amount of conspiracy going on, most of which is never looked at because it's really trying to protect the reputation of the bar and to weed out people who obviously have infringed. Now, of great use to all readers, I think, is the forensic examination of leading decisions in the Court of Appeal specifically, and the author offers tips on the best approaches to a BSB investigation, how it's actually conducted, which of course will not make him any friends or help to influence people in various quarters, but I think it will be of great assistance to a defendant, a prospective defendant. Marc's never shied away from dealing with some of the more modern aspects of the way we do our business. That's the direct access scheme and of course disciplinary proceedings. And for bar students there is now of course an examination on the concept of professional ethics and misconduct. So I think the book will be very helpful for all trainee barristers and basically explains how the current regulatory system operates in the 2020s. There's also a seasoned advocate's deconstruction of disciplinary trial preparation and conduct, which I think would be very helpful for the uninitiated. And we did find the approach to sanctions, which was given a distinct treatment, of great assistance also, because normally it's a fining, sometimes it leads to disbarment and suspension, but there is what is also described as a unique chapter on barristers and human rights, which frankly is quite often overlooked in the zealous approach to discipline barristers. Sometimes the Human Rights Act has been ignored, but it does look at the impact of the European Court of Human Rights, specifically in relation to Articles 6, 8 and 10 on barrister discipline, which I found helpful. We do not look as though we're going to have any changes to the human rights legislation for the foreseeable future, but at least we've got some idea of the approach used if you are looking at a human rights issue concerning what has happened. Other chapters in Beaumont on barristers cover areas which include costs, which is always a very big area because costs involved in an investigation are very high. Obviously disposal by consent, effectively a little bit like a caution if you like, appeals to the administrative court, and defending complaints made by the legal ombudsman, which is the final chapter. The role of the legal ombudsman is amazing. There's a very substantial feeling of criticism about the role of the ombudsman even today, from the time when it was first created, and that hasn't abated. It's in urgent need of reform. Let me conclude by saying this. It's a highly original title from Marc Beaumont, and he draws from unreported case law, which he's got a huge amount of knowledge of, in addition to the leading decisions. And in his own words, he says he takes an area of law that is misunderstood and stigmatised and elevates it to the level of a respectable legal specialism, whilst being both the reader's friend and guide. And that's exactly what you get. So thank you, Marc, for being brave enough to hit the pressure points so successfully with what I think is a highly original work. What you've done is you've endeavoured to state the law as it is on the 31st of March 2020, both in reported and unreported sources, and the publication is dated at the 11th of June 2020, and I'm recording this in July. Thank you to Marc. Let's have a quick last look at the book. It's a paperback, there it is, the spine and then the back, then just opening it in the middle. Trial preparation and conduct. Again, there's a huge amount of work that Marc has put in, looking at what's happened in the past and some of the serious problems. Then you've got sanctions, for instance, here again, proportionality on fines and various other matters, reprimands, public access cases and so on. And as I say, right at the back, you've got the legal ombudsman matter, which I think is important because that's the first starting point for quite a few people. And as I say, from what I've seen, many of these cases are malicious and totally lacking in any form of merit. Anyway, thank you, Marc Beaumont and Law Brief Publishing for having the guts to produce this work. I think it's extremely helpful and we're very grateful. Bye-bye.